if you wouldn't mind waiting just a moment so we can clear the hall and the noise.
No worries.
Okay. All right. Very good. We're on file item 7, AB 289. Assemblymember Fong, the floor is yours.
Thank you, Madam Chair and members. It is my pleasure today to present AB 289, which is jointly authored with Assemblymember Gonzalez. When the legislature passed the California Public Records Act in 1968, it stated, access to information concerning the conduct of the people's business is a fundamental and necessary right of every person in this state. Currently, state agencies have been able to subvert the California Public Records Act by citing PRA exemptions as the basis for denying a request, even though the exemptions they cite have nothing to do with the request for public information. State agencies are doing this because they know there is no appeal option other than to sue the agency in court, which is not feasible and too costly for many in the public. This bill addresses this problem by establishing an ombudsperson who can, upon request, review the denied Public Records Act request and serve as an independent referee to decide if the state agency had legitimate grounds for denying the request. AB 289 addresses a loophole in the Public Records Act process so that it can do what was intended, which is to bring transparency, fairness, and accountability to state government for the very people that we serve. 19 other states have adopted some form of independent referee in this capacity, and California needs to do the same. With AB 289, California has the opportunity to lead on an important bipartisan effort to bring more transparency to our government. This bill has received unanimous support in the Assembly and is supported by major media outlets statewide, such as the San Diego Union-Tribune and the LA Daily News, and we've also received editorials and support in the LA Times and the San Francisco Chronicle. This bill is also supported by the California Civil Liberties Advocacy and the League of Women Voters. With me here to testify in support of this bill is Whitney Prout with the California Newspaper Association.
Good afternoon, Madam Chair, members of the committee. The California News Publishers Association represents hundreds of community newspapers throughout the state of California who rely on the California Public Records Act as a crucial tool to do their jobs to report the news. As we see it, AB 289 provides 3 key benefits that further the purposes of the California Public Records Act and the constitutional right to public records that's enshrined in Article 1 of California's Constitution. First, it helps reduce the burden on the judiciary of Public Records Act cases in situations where a requester uses this process that could bypass the judiciary and relieve the caseload on the courts. Second, it provides a remedy to enforce their rights under the Public Records Act that a requester without means may not otherwise have. As we know, a right without an accessible remedy is not a very effective right at all. And while the use of the court system can be very effective, it's not something that's accessible to a small community newspaper or an individual watchdog. By adding this additional tool into a requester's toolbox, we believe that this is going to help further the purposes of that right. And finally, it also provides a benefit even to those who don't directly utilize the process, because the opinions of this ombudsperson would become public and could be used as guidance both for requesters as well as public agencies in the future. And so we're supportive of the concept of the bill and are happy to be here in support of it today.
Thank you. Are there other witnesses in support? Any witnesses in opposition? All right, we'll bring it back to the dais. I appreciate what you're trying to accomplish here, Assembly Member. You and I have had conversations about it. I have 2 pages of concerns, and I think they are expressed in the analysis of the bill. I understand that the newspapers would be in support because it actually doesn't provide an opportunity for appeal by the agency against whom or upon whom the request is made. So as I read this and as we've discussed this and staff has analyzed it, I think there are just too many unanswered questions and unintended consequences, which I'd like to articulate. Because we have given this a very serious look, and we understand and appreciate the Public Records Act, and I know, speaking for myself and probably for everyone here, as many of us lawyers and all, we support the Public Records Act. We do need to have that sunshine. But this bill drastically changes how the CPRA is enforced by having one individual make the determination if a record is disclosable under the CPRA instead of the courts. We're moving the authority, the jurisdiction away from the courts. There is no way for a state agency to appeal a decision of the ombudsperson. Under existing law, a state agency can appeal a Superior Court decision regarding the CPRA. There is no way a person whose information is implicated by the records to be able to intervene to advocate for their privacy rights. The consequences here are grave. Once private information is disclosed to the public, it cannot be taken back. It creates a two-tier system of enforcing rights under the CPRA. It applies equally to state agencies. The CPRA applies equally to state agencies and local agencies, but the bill only applies to state agencies. I will go on because, or I can go on, I guess I should say, but there are significant problems associated with this. Lack of ability for both sides to appeal. State agencies, it applies to them. The existing law makes determinations exclusively a judicial function where the courts have to balance two fundamental constitutional rights, the right of privacy and the right of public access. That's why we have the system set up as it has. The ombudsperson is not required to have any judicial experience or even be a licensed attorney. So it's unclear what the bill is doing. Is this a new administrative remedy or not? Is the ombudsperson's, we got to find a better name for this, but anyway, is there issuing an advisory opinion binding decisions that have to be followed? Would rules of evidence apply? We're giving authority here to the state auditor to be the one to, we're going to place the agency there. The state auditor is subject to the CPRA, so there's potential that the ombudsperson would have to review a decision by the state auditor's office to deny disclosure of a public record, leading to a conflict of interest. The concerns go on and on. We've discussed them. I appreciate that you are looking for a better method. I would suggest that with all those questions, that this bill is not ripe for prime time. It has, I think, too many significant questions associated both with the public and privacy rights, as well as that balancing of public access. So again, I would say I would leave it at that. I went on a little longer than I had expected, but there are many, many significant problems associated with this measure. I would ask, and you're here, you want to vote, that's fine. I would be happy to continue discussions going forward so that we could perhaps address some of these problems, but basically taking this from the judiciary and putting it in the hands of one person creates some very, very serious issues in and of itself. So those are my comments. Yes, Senator Borges.
Thank you, Chairwoman. I believe that fundamental in our constitutional republic that access to information is key. And I think FOIA and the California Public Records Act, the federal and state respective equivalents, is absolutely imperative that we don't rely on faceless, nameless employees, bureaucrats, if you will, making decisions that force individuals into a legal system that we all know and have heard about, at least for the course of this legislative session, on how backlogged it is and how difficult it is. And for those who are not fortunate enough to be in a financial position to seek redress in the courts, that this is precisely, I think, what we need. We need to have an individual responsible that can oversee these matters in a timely fashion. I think 30 days may be a bit short when it comes to, but I think it's admirable. I think I wanted to clarify a point. I want to make certain I understand this, that if there is an issue with an ombudsman's decision to disclose or not disclose, does that foreclose a party's ability to go to court and seek redress?
No, absolutely not. We still preserve the right for any party to go to the Superior Court to seek relief. What we're trying to do is we're trying to create an appeals process in between the rejection and a lawsuit. Mm-hmm. Are you going to say that the only recourse you have to get information that you as a public person deserves and is in the Constitution as your right is that the only way you're going to get that information is to sue the state government? And that you now have to have the resources to do that. We're trying to rebalance the CPRA. Right now, the scales are tipped completely against the public. It is completely on the side of the state agencies. And so at what point do we allow someone of the public to get the information of why a decision was made by the state government? The committee itself presented amendments to all the concerns listed in the analyses, and we accepted all of them. So to say that somehow these issues cannot be addressed, we provide clarity to show that appeal can go to the Superior Court and that they will cover the costs, that there is no legal precedence, that the ombudsperson has to be chosen with expertise in the California Public Records Act, and that we clarify that this review does not have legal precedence and can move forward. So what we're trying to do is that if an individual wants to seek information from a state government, it's David versus Goliath. Are you going to tell me that an individual right now can take on and ask for information to the state agency and that they're going to win? What we're trying to do is just balance the scales. We don't want it to be tipped either way. But if we can find any independent person, I'm willing to look and work with the committee and work with any member. If it's the Legislative Analyst's Office, if it's the auditor right now is that entity right now. And right now, as we debate bills, a lot of the bills we're debating in the legislature says that if you need to seek information from the state agency, what do they need to do? They need to file a Public Records Act. Well, then how does someone do that if they can't get any relief? And so that's what our bill is trying to do.
Let me give an example here. Maybe you can flesh it out. An entity files a FOIA request or public records request. And my concern is that if the state government or any of its instrumentality discloses a document that, for example, might have personal information on me, my social security number, my passport, so on and so forth, do I have the ability to write a letter to the ombudsman and say, however you decide this, my objection is that it will reveal confidential information about my identity. So if it is disclosed, will you please direct that information be redacted? Is that contemplated in this?
We're willing to work that out. We actually took amendments to address that. The ombudsperson doesn't make these decisions in a vacuum. They are seeking information from the individual, from the news outlet, from the organization, from the state agency. So before any information is made public on a website, all that information is going to be worked out. It's not going to be this freewheeling process where all of a sudden the ombudsperson says, you know what, I'm going to make a decision and I'm going to throw everything on the web. This is a very careful process, and so we want the appeals process to be taken very seriously. This is not one, yeah, so this is why it's so important.
Ombudsman says, I don't believe that your passport information is confidential, and I will release a report, and it will be made available in a period of time on the website. I then have the opportunity to challenge that through the courts to make certain that does not occur.
Absolutely.
All right. I've seen a lot of bills in the course of this session. This is, I think, at its beating heart, a bipartisan issue. I mean, it really is. I mean, just look at your co-author. I think it's admirable. I have consulted with folks in the media and newspapers. This is important, and it's not just for those that are in the business of information brokering. It's it's everyday residents of California, citizens of the U.S. So I applaud you for moving this forward. I think this is exactly what we need to make certain that David and Goliath, that one of them is brought down to size.
And I might, if I may add, I'll just quote very quickly. If you look at all the information that has come out on whether there's the DMV or the Real ID, the Motor Voter Program, all that information was obtained through the Public Records Act in some form or fashion, but it took a long time. And I'll defer to my colleague here, but you can't say that a news outlet must sue the state government, and that's the only remedy to get information that we all deserve to know.
So I want to just point out here that the statement that you had made earlier, I don't believe is accurate. It says here, you indicated there was the ability to proceed in a superior court. It says if the ombudsperson determines the state agency improperly denied disclosure of the public record or records, the ombudsman shall require the state agency to provide public records or records to the member of the public who submitted the request for review. That does not allow for, that does not allow for an appeal. Now, you are also putting in the hands of one person the authority to make this decision. I think we all agree there has to be greater transparency. So that is clearly, I think, a bipartisan issue. It is the way we go about it. Do we really want to give the power to make these decisions to one human being? Period. And that's what this bill does. So I could go through the litany of other problems associated with it. The CPRA today allows for attorney's fees if that person wins the case. You use it as the example that was given. Someone can say, I don't want my information being used. How are they going to know it's even being sought? I mean, there are just too many issues here, and you're trying to take years of precedent and put it into something that is truly not baked. And I think it creates a very dangerous precedent to put this kind of power in just one person sitting in an office where there may very well be a conflict of interest. So I am happy to continue working with you on this bill. I don't see where we need to be going forward with all of these questions still unanswered. You indicated you'd be happy to continue working on some of these issues. This is a huge change, and it requires real deliberation so that all parties, so that this is balanced, and all parties have an opportunity to be heard and made their case in a nonpartisan, unbiased fashion. That's why we've used the courts up until now. But to create this ombudsperson with all this power, I think really requires that we be more contemplative. This is not, this bill is not the answer, certainly not as it exists today, in my opinion. Yes, Senator Monti.
Well, thank you, Madam Chair. So I applaud your bringing this forward. I think we all share the objective, which is to try to level the playing field and create more equal access to public records information. But I share many of the concerns voiced by the chair, the list of questions. I think I've heard you address some of them, but maybe not all of them today. What's the person's training? What's the precedent nature of a ruling or decision they might make? I'm not prepared to be supportive today. I am prepared to support the chair and the committee in working with you and your co-author to try to answer some of these questions and create a system that protects the due process rights of all. And that due process, when you cast it as an individual who seeks access to public records versus a monolithic bureaucracy, well, some of the records within that monolithic bureaucracy might present privacy concerns for an individual state employee, a frontline employee. And so the balancing act that the courts currently exercise protecting the due process rights, this has to be ironclad to make sure that those due process rights are indeed protected. So I'm not prepared to be supportive today. I am prepared to work with the chair and the committee and the authors to see if there's a pathway to achieve this objective. Thank you.
Thank you, Mr. Senator Monning. Any other comments? Assembly member, you may close.
I will just say thank you, Madam Chair, for the for the dialogue and the questions. And certainly, I want to work with your colleagues and yourself to find something that works. And I believe that we can. The questions and the concerns outlined can be easily addressed. 19 states in the union have done this, from Arizona to New York. And as I'll just close by saying, as the California Supreme Court wrote in CBS versus Block, implicit in a democratic process is the notion that government should be accountable for its actions. In order to verify accountability, individuals must have access to government files. Such access permits checks against the arbitrary exercise of official power and secrecy in the political process. This bill should not stop right here. It provides transparency, and it gives public greater access. I urge an aye vote.
Thank you. In response to the fact that other states have done it, some states have binding authority, others only advisory. It's not clear if these states have public records laws that are analogous to our CPRA, especially with regard to the permissive exemptions. But I certainly accept your desire to keep working on this. I think there is a way to get to that important balancing so that the information is available while we also carefully consider privacy rights. I want to commend you for bringing this issue forward, and while I will not support this now and believe that it is far too premature with too many questions, and that is my recommendation to the committee, I certainly am happy to continue working with you because I think the cause here is an appropriate one and one that I think we can ultimately get to. But I think this is not it. So with that, we need a motion.
I would certainly move
Very good. We have a motion. The motion is it do pass or do pass as amended? All right, so it's a motion of do pass.
I think the committee withdrew their amendments.
I'm sorry?
We accepted the committee amendments, but they were withdrawn, so
All right,
I
so
believe
the motion is do pass. Please call the roll.
Sorry, point of clarification, Chair.
Yes.
Just want to be clear. You mentioned amendments were withdrawn, say that?
We were working with the committee. The committee had made amendments that we accepted, and as the chair, I think, raised some concerns, those amendments were withdrawn.
Wish for them to be included?
I'm happy to accept the committee amendments.
Fine. It doesn't impact. There are so many concerns that we've expressed. If you want to accept those amendments as authors' amendments, we can continue to vote on this as a. I'm sorry. All right. So those amendments, if this bill were to pass, would be taken in GO. They couldn't be taken here. So the motion is do pass as amended. Please call the roll.
I'm sorry.
The motion is do pass to GO, where the amendments would be taken if the bill is to pass. Okay?
File item number 7, AB 289, Jackson.
No.
Jackson, no. Borges. Aye. Borges, aye. Durazo. Gonzalez. No. Gonzalez, no. Jones. Jones, aye. Monning. No. Monning, no. Stern. Umberg. Wykowski.
The 3 votes, and we will leave the roll open. Thank you very much.
If I may request reconsideration.
Excuse me, you have 2 votes. The vote count is 2 ayes, 3 noes. We'll leave the roll open.
And may I request reconsideration?
Of course. Thank you. All righty. File item 8, Assemblymember Daley. AB 355.